Hi, Bill Henshaw here again, one of my ongoing YouTube videos on current events. And this one is not as current as a lot of mine is, but I want to talk about a very important case that deals with issues arising pursuant to the 14th, what I call the non existent 14th War Amendment. And it's a case out of the Ninth Circuit called McDonald versus United States, one of the biggest BS decisions I've ever seen. And I've seen a lot of crap over the course of 5 decades. But the good news here is that you'll learn. I'm going to talk about this case and what the court said and what it didn't say and why. And these are the sorts of nuances you'll learn, by getting a hold of my modestly priced constitutional defense document packets, which I recently reduced by a third in cost, given the holidays and the ongoing COVID pandemic crap. But you learn how to deal with this and understand that this case can't hurt us, even though initially it may look like we have issues decided against us. That's the last thing from being true once you understand how the just system does its dirty business. So in any event, this McDonald case does appear to discuss issues, like what we're going to be raising. And I admit up front, these are openly, quote unquote, white supremacist arguments, but they're winners, every one of them. It's the way the nation and republic was founded, and that's the way it is. And the other side, including Rudy Giuliani and other bastards like this, are going to tell you that the 14th Amendment reversed everything. No, it didn't. It couldn't have, since the ratification of the non-existent 14th War Amendment violated all 6 articles of the Constitution. That's how simple that is. And therefore it couldn't have. And in any event, those who ratified the amendment were never made aware of any of the secret agendas of this amendment, including making citizens out of corporations who then owe their birthright citizenship to that amendment and can be completely controlled not only by government, but by all the bastards in Washington, D.C. and the de facto Congress that has nothing close to a quorum to do business in either house. And really, they have 0 in the House and 0 in the Senate. Videos for another day, but trust me, I can prove all of that. So that said, the Ninth Circuit dismissively says, oh, this is the usual white supremacist crap we see and this, that, and the other, and therefore we're not going to rule on it. And then they attempt to address issues surrounding the ratification of the 14th Amendment. And I have yet to see any cases that have attempted to do that besides this one, and only recently. And this is a big deal because the U.S. Supreme Court, they have a thing called the Ashwander Doctrine, comes out of their decision of Ashwander v. Tennessee Valley, 297 U.S. 288, on the rules of what they will hear and won't hear. And like I say, you send me information, email at youwinincourt@gmail.com for information on my document packets. You get a lot of bonus documents. One of them is this doctrine from Ashwander, which was on the first page of the first law course I took back in 1983. I didn't fully appreciate it, but I do now. And the court says in there, for example, almost verbatim quote, that the court will not pass upon the constitutionality of a law prior to the necessity of its being before the court. They didn't say it quite that way, but if you don't ask, we're not going to answer. This is what allows these bastards to go to sleep at night, because they know damn well that none of the attorneys in the Supreme Court bar are probably going to know these issues, let alone be willing to present them potentially at the course of their careers and maybe their lives even. And most of us, having gone through the mandatory public education system, didn't learn a damn thing. I certainly didn't 50 years ago, or my life would have been quite different if I would have read President Andrew Johnson's veto speech of the Reconstruction Act of 1867. The ballgame would have been over. I mean, he called that act exactly what it was, a bill of attainder against 9 million white Southerners. To the extent that wasn't true, it's only for the reason that really it applied to everybody in the country at the time, black, white, no matter where you were. That's exactly what it was, and it was the use of war powers by Congress when they had no authority to do it. And that's the basic flaw with civil rights. The Freedmen's Bureau, which was the first bureau erected under the Civil Rights Act of 1866, under the perpetual control and protection of the United States military. What does that tell you? War war enactments, and war enactments are governed by the president acting as commander in chief. And if you wonder how come so much law, quote unquote, these days is made by executive order, this is a big clue as to what's really going on and what we have to fix if we're going to save ourselves, our children, and our posterity. We start raising issues like this and across a broad spectrum, Americans, Africans, Asians, the quicker we do that, the quicker we'll stop the bastards and get rid of this civil rights crap, Jesse Jackson and Al Sharpton. You ought to damn well know better, and you're making good money off the backs of your own people by seriously misleading them and not wanting to solve the problem, because if you did that, your jobs are going to go away now, aren't they? Same thing for the NRA with gun control. They've been hanging on to the Second Amendment crap for 140 years when the Supreme Court said back in the day that that's not the issue. And they were right. It wasn't the issue and isn't. We have much better provisions of the Constitution than to do that. And the sooner they get away from that, the better we're all going to be, especially if we are headed into an overt martial law rule here, where we're going to need firearms to go out there and invoke our right to self-defense. Video for another day, but trust me, Presser v. Illinois, 1886, said it wasn't a Second Amendment argument. It wasn't then. It isn't now. Get off it already. So that said, returning to our subject matter, the 14th Amendment, and I refer you, by the way, to earlier videos I've done on the 14th Amendment and on no states. That's the crown jewel of everything I do. There are no states that would be recognized by the framers of the Constitution today if they were here. We don't know what they are. I personally choose to call them what I believe they are: federal, insular, territorial possessions, completely governed pursuant to Article 1, Section 8, Clause 17, that's the District of Columbia, if you don't know, and or Article 4, Section 3, which is the territories, and in particular, insular territories. The difference being insular territories, in theory at least, never had a future in becoming a state and were therefore a different animal altogether. Think here, Alaska, Hawaii, Puerto Rico, Guam, places like that, they aren't going to become states or wouldn't be likely to. And that's what you're talking about here. And they have very little in the way of rights. There's a whole series of insular cases that you'll learn about when you acquire my document packets. The Supreme Court talked about just this kind of thing back at the turn of the century in 1900. And when you understand that kind of law and what it really means, and if you don't know what you're reading at first, you might confuse that with a lot of case law crap they're handing out these days. It's the same problem, the same philosophy of collectivist government, and it has nothing to do with life, liberty, and pursuit of happiness and creator-endowed inalienable rights. And I hope we're not drawing ever closer to an end of the United States here with all this COVID crap going on and the martial law rule they're doing. And I think Trump is on the right side of the issue there. I wish he would have told the American people during the campaign a lot more than what he did about what he was doing and why. As I've just said in a recent video, we'll see how this election ultimately comes out, because it's not over. What I've been hearing is there are serious problems in some key states here with voter fraud, especially with mail-in ballots. Don't have a lot of hard evidence on it at this point, and apparently neither does Rudy Giuliani, who made an ass of himself in a recent hearing in the Court of Appeals, first time he's been there in 30 years. Probably lucky he didn't get cited for contempt. But that said, we'll see what develops with this quote unquote election. I mean, who the hell knows? I think it's all good in the end, but we will see. But in any event, this McDonald decision, the Ninth Circuit, without identifying any of the issues that this guy raised in his case, McDonald, said that they were all political questions. Now, if that's true, and he may have not raised nearly as many issues as what I do and what I'll be teach you to doing that arise under all 6 articles of the Constitution. If those are political questions, then we don't have a constitution, because it could be changed at the will of one man, basically the president acting as commander-in-chief of the armed forces, and any other local bureaucrat that wants to do anything he wants to do, knowing there's going to be no reviews because we have no judicial courts. That's how serious this is. So like I say, I'm going to teach you, how we get around McDonald, and we do it easily, and we use the Supreme Court's own cases and their own words to bite them in the ass when we get there and tell them in no uncertain terms, you can't do this. Either we're entitled to judicial courts and trial by jury according to the course of the common law. And that, by the way, people, was true back in the day, coming from the Northwest Ordinance of 1787, Article 2, and it was reenacted by the first Congress. Inhabitants of territories, yet state citizens don't have a right to trial by jury? What the hell is the problem here? You send me an email, youwinincourt@gmail.com. I'll give you a real heads up on what the problems are here and how to deal with them. And you can learn, teach your children, they can teach their children, and get our posterity out ahead of this. So it's going to be very difficult, if not impossible, for the government to subject people who know what their rights are to doing anything to them that they want to do. I'm pretty much there right now. They don't bother. They won't even file charges at times against me. And when they do, I stop them by, among other things, demanding that they define dollar, which is undefined according to the Federal Reserve Chairman, Mariner S. Eccles. Can't define it, then they can't prosecute you for a willful failure to pay, can they? Likewise, in terms of a willful failure to appear, they can't come after you for that either. If they have a court that not only doesn't have jurisdiction, but refuses to answer the demand of bill of particulars, which the local dumbass has the sworn duty to do and sustain jurisdiction of the court so you know where the hell you are. If you don't know where you are, the rules of the game, the identity of the elements of the crime, and can't confront your accuser, why bother with the trial at all, aka a directed verdict of guilt in Black's Law Dictionary? Why bother? Get it over with, be done with it, just like what they used to do in Stalinist Russia. Put a gun to their head, get them to confess, and shoot the bastards. It's not all that different here, even though it may on the surface look that way. But that's the point of what I'm doing. And the whole exercise, and I just wish I had known 50 years ago, if they would have taught me in high school, I would have been getting the word out a long time ago. I didn't have a clue either. I was so damn stupid at the age of 19. I volunteered to go into the U.S. Marine Corps at the height of the Tet Offensive. Probably would never have come back, except that my beloved mom put a curse on the Marine Corps and said, they're not going to get him. And everybody laughed at her and said that you're crazy. Yet it turns out, and I have documentary evidence from my dismissal from the Marines with the shortest tour of duty in the history of the USMC, probably still true today, 3 hours. Got out the same day. The call to come home to get me was so quick, my parents hadn't got back from taking me. Of course, this is an era long before cell phones, mind you. But I was home the same day, never made it to Paris Island. Boy, would that have been interesting if that happened. Because I had a lot of sensibilities about just knowing when things were wrong. But they didn't teach you. You just had to instinctively know this. And I grew up on the summers, especially, down on the farm in Virginia and at my grandparents' house in West Bygosh, Virginia. I didn't know, by the way, at the age of 8, why it was called West Bygosh, Virginia. And this is the issue that split my family. Mom told me they never discussed it because my grandparents were on different sides, which was a common occurrence then. But West Bygosh, Virginia comes from the fact that even Dad Stevens, that son of a bitch from the 39th Congress that basically headed up things, for the Reconstruction and all that, stated on the record that West Virginia was admitted pursuant to the war powers of Congress. It's a war state. It is. It was unlawfully taken away from Virginia. And this is a video for another day, but you look at your map, you're going to see why that happened right during the middle of the Civil War in 1863. So in any case, I spent a lot of time down there in the shadow of Jeffersonian republicanism, and I picked up a lot about how those people lived and did their lives then. And it was quite a lot like that. It hadn't changed in 100 years, since most of these things that happened with the war between the states. So I learned a lot just from being down there and experiencing that. And, you miss it. And by the way, I can say the same thing for Harpers Valley because I was up there in that same time frame, went through and visited with John Brown's raid and all that. And it was pretty much the same town it was 100 years ago. Probably not nearly as true now, almost 100 years, almost 60 years later, but still, I grew up in that era. It was a great era. We still believed then we would do better than our parents. See if you can find any millennials around that thought that when they were growing up, but the new generations coming up now, whether they're going to think that. But back in the day, we had that reasonable hope that we could do better because the New York bankers hadn't gotten to the level of control they're trying to exercise now. So that said, some interesting materials you can get at a very, very reasonable cost. I just reduced my document packet price by a third, given the upcoming holiday season and the ongoing COVID crap, and who knows when that's going to end. But the net effect is you can get all these materials for about 1/100th of 1% of what it would cost you to go to a 4-year law school like Starboard, Bayeux, Berkeley, you name it, if they were still teaching the Constitution, which they don't do now and haven't done probably in a good 75 or 80 years. I think Rehnquist and O'Connor may have gotten some of that when they were in Stanford in the 1940s, but you may have to go back that far. And my personal cutoff date for books, especially law books and history books, is 1930. After which time, the powers that be took over most of the publishers at the time, and you can't get books published like this anymore. So you have to go back a way. Some of my best books come from the 19th century. I've got a set of books that talk about Reconstruction and the Constitution, the Civil War and the Constitution in the 1890s, back in the day when it was still within living memory. And you read stuff like this and get the real picture. It wakes you up in a hurry. Trust me. So that said, remember to subscribe, like my videos, tell your friends, get the word out. The quicker we do that with the more of us across the spectrum here, Americans, Africans, and Asians, the quicker we get these bastards off our backs. Thank you.